In this episode of News from Poland Business and Law, we will talk about the hearing of a foreigner, especially a member of a company's management board, and how it may look if the person has to testify in a Polish civil court as a party to the proceedings.
Our program is intended for foreigners acting as board members in Polish companies, foreign investors in Poland, and the foreign advisors.
Let's get started.
A party to a dispute in court may be the person who is suing, namely the claimant, or the one who is being sued, in other words, the defendant. This may be either a physical person, in other words, an individual, or a company whose rights and obligations will be affected by the judgment. If the party is an individual, then that person will have to testify in person before the court. However, if the party is a company, then the persons who serve on its management board will testify on its behalf, because the board members are, as it were, the mind and the mouthpiece of the company. They will always testify as a party. They cannot testify as witnesses. However, if the management board has 2 or more members, it is up to the court to decide whether to hear all of those persons one by one or just some of them.
In a court trial, the parties to a dispute have to prove their case by using legal arguments and various pieces of evidence, particularly documentary evidence, which has priority in commercial cases, and by using the testimony of witnesses. Evidence should constitute facts that are of significance for the resolution of the case. Evidence taken from a hearing of the parties constitutes only auxiliary evidence. This means it is only admissible for circumstances that are significant for the case and cannot be explained by other evidence, and the parties filed an application for such evidence to be taken. Under the Civil Procedure Code, if all the significant circumstances of the case have been explained by documents and testimonies of witnesses or court experts, it will be unnecessary and even inadmissible for the court to take evidence from the testimony of the parties. However, in practice, courts almost always admit evidence from a hearing of the parties. In our experience, this evidence is important because it is taken at the very end of the proceedings, when the trial's outcome is being decided. This is, of course, only so if a testifying board member possesses key knowledge of facts that would be significant for resolving the case.
A feature of evidence taken from a hearing is its symmetry. If the court decides to hear one party, it should also hear the other. In practice, however, there are often situations in which the representatives of only one of the parties to proceedings was involved in the particular transaction, while on the other side, the management board has very little or even no knowledge of it. This happens, for example, in large corporations. In such a situation, the court restricts the hearing to only the one party that has knowledge of the matter, either the claimant or the defendant, or altogether dispenses with hearing the parties. If a party refuses to give evidence, the court will not be able to penalize it for the refusal, for example, by fining it, or to compel it to attend to court. The court may impose such penalties on witnesses because they have an obligation to testify. Therefore, the court does not possess any legal instruments which it may use to compel a party to give evidence. A party that refuses to give evidence simply runs the risk of losing the trial, because the court's interpretation of its own internal doubts may turn out to be unfavorable for that party. So it is in the party's interest to submit its own testimony.
Any anticipated non-appearance at a trial due to, for example, illness or long-planned foreign holiday must be excused. However, an excuse involving illness requires the production of a certificate from medical practitioner. Information about the locations, dates and appointment hours of special court-appointed medical practitioners is available from court websites.
The rule is that a party, just like a witness, gives evidence orally. Before the COVID-19 pandemic, the rule was that witnesses and parties would give evidence during a hearing held in a courtroom inside a courthouse. However, a rule was introduced at the start of the pandemic for evidence to be given during remotely held hearings. Such hearings have really caught on and are now very common, saving parties the time and money they might have spent on traveling to court. A claimant or defendant who submits an application to hear board members as parties must provide the court with their mobile phone numbers and email addresses. A person who is summoned to give evidence receives an email from the court with a link to an internet connection and then connects to the court at the time of the hearing.
This concludes the first part of the program on the examination of a foreigner as a party in a Polish civil court. We will soon publish the second part of the program on this topic. See you then.